No problem, that's fine, take your time.
Chair, I make opening submissions in respect of the two remaining Bat-Murphy non-state core participants D1713 and D1473. You've already heard something of both of their experiences in the opening submissions from counsel to the inquiry a few days ago. May I start by echoing what was said by Miss Liu at the outset of her submissions yesterday in relation to the certain common features which apply to all 5 of the formerly detained persons represented by Bat-Murphy, in particular that it is simply not possible to capture the extent of their experiences by focusing on discrete incidents of physical and verbal abuse alone. That is because the nature of the mistreatment that they suffered was often both complex and composite, informed by a range of contextual, clinical, and institutional factors which operated together to effect very real, though often unseen harm. What we provide now, therefore, is only a snapshot of their experiences, one which will necessarily be amplified through the course of the evidence that you yourself will receive within this inquiry. If I could start then with D1713, his evidence, we understand, is due to be read within this phase of the inquiry. However, we do intend to revisit his experiences again in the context of the evidence that will be submitted on behalf of medical justice in phase 2. D1713 is a Nigerian national who is now a recognised refugee. He was detained at Brook House for 2 periods, from the 31st of March to the 17th of April, and then from the 20th to the 22nd of April in 2017. In the short intervening period, he was transferred to Harmondsworth, where he was then returned to following his time at Brook House from the 22nd of April to the 2nd of July. He was then transferred to Colebrook briefly before being released on the 3rd of July. D1713's treatment at Brook House and the circumstances of his detention starkly illustrate the deficits within the framework of systems, policies, and safeguards which are designed expressly to prevent the detention of highly vulnerable individuals such as him. Following his release from detention, D1713 was diagnosed with PTSD and depression by several successive clinicians. The most recent medical legal report which has been provided to this inquiry finds that it was the significant mental trauma that D1713 suffered in detention which led to the development of both of his conditions. The same report has assessed him as lacking capacity to provide oral evidence in this inquiry in view of the risk of significant and permanent re-traumatisation. And that should not, of course, in any way diminish the centrality of his narrative within this inquiry, but rather reinforce it, in circumstances where his inability to participate is closely related to the very fact and experiences of his detention. Prior to arriving in the UK, D1713 suffered from various traumatic experiences. As a child, he was subjected to sexual and physical abuse and was forced into labour exploitation. He was also the victim of a brutal attack, where he was burnt, repeatedly beaten, stoned and whipped. However, during both periods of D1713's detention at Brook House, the critical safeguards under Rule 34 and Rule 35 were not applied adequately or in fact at all. His history of torture was not identified in neither of his reception screenings at Brook House, and there being no evidence to indicate that he was ever even asked the relevant questions, nor on both occasions did he receive a Rule 34 compliant assessment. There then followed a severe and inexcusable delay in identifying D1713 as a victim of torture who required assessment under Rule 35(3). During the first period of his several weeks' detention at Brook House, D1713 made repeat and express disclosures to healthcare staff concerning his past torture which were, it appears, entirely ignored. For instance, in his GP review on his very first day of detention, D1713 reported that he had scars from being cut on his face and back, that he was suffering from flashbacks, that he was scared of himself, and that he was scared to look in the mirror as he was going to harm himself. But despite these clear indicators, the GP failed to ask D1713 any questions to elicit a possible history of torture or to undertake an examination of his scars. Nor did he open an act, even when faced with D1713's pronounced self-harm ideation. And later, that very same day, D1713 went on to report in a mental health review that he had previously been physically abused and beaten and burnt. He even went as far as to physically show the nurse the scars that he had sustained to, in the words of the nurse herself in the medical records, confirm this. He presented as very distressed and reported suffering again from flashbacks of these experiences. The nurse records his plea in the medical records, "Please God, don't let me do something stupid." D1713 was at this point belatedly placed on an act. However, his explicit self-reporting of past physical mistreatment failed to provoke any concern that he may be a victim of torture, who required assessment under Rule 35.3 in respect of his ongoing suitability for detention. Similarly, nothing was done the following day when he told another registered mental health nurse that the confines of detention were causing traumatic memories to resurface of what happened to him as a child. This inaction, if not willful indifference of healthcare staff in response to obvious indicators of vulnerability, continued upon D1713's first transfer to Harmondsworth on the 17th of April. He reported there in his reception screening that he'd been assaulted, and various scars were recorded on a body map which was included within the medical records. But notwithstanding this, no Rule 35.3 assessment was conducted even then, during his several days at Harmondsworth, nor following his return to Brook House on the 20th of April. It was only following D1713's move back to Harmondsworth once more on the 6th of May that a Rule 35.3 report was finally completed. Now, this was some 5 weeks after he was first detained, and indeed some 5 weeks after he had first disclosed his history of torture, which ought to have prompted in and of itself a Rule 35 report, and if properly considered under the Adults at Risk framework, ought to have resulted in his timely release. The fact that D1713 persevered in reporting his traumatic history again and again, entirely unheeded, perpetuates this fundamental failure with increasingly severe effects on himself. D1713's experience is particularly concerning in the context of a system premised on the precautionary identification of vulnerability, where a Rule 35.3 assessment should be arranged wherever there are concerns by way of physical or mental indicators that a detainee may have a history of torture. The triggers for referral for a Rule 35 report and assessment will necessarily then range from express disclosures to the presentation of indicative psychological symptoms. If, however, a detainee such as D1713, who consistently and explicitly referenced his history of torture and even showed his scars to the healthcare staff on 2 occasions, if he is unable to avail himself of the Rule 35 safeguards when necessary, and by that I mean before the risk of harm has arisen, then there is little hope for those many more victims of torture in detention who, for reasons linked to their underlying trauma, are unable or unwilling to disclose those experiences entirely unprompted. This presents a serious and fundamental failing in the Rule 35 framework, which, even before we arrive at issues of defective operation, often falls to be disregarded or disimplied entirely. It is also necessary at this stage, Chair, to turn to the issue of clinical care provision in his case. As I hope is already clear, D1713 presented with serious psychological symptoms from the outset of his detention at Brook House and throughout. He repeatedly reported to healthcare staff that he was suffering from traumatic flashbacks, thoughts of suicide and self-harm perpetuated by the conditions of detention. However, despite this, he never received a detailed psychiatric assessment to underlie and identify his mental health conditions. This would not have only enabled his medication to be reviewed and optimised, but would likely have led to appropriate clinical signposting, such as referral for individual psychological therapy. Instead, D1713 was simply prescribed antidepressant medication, and he received intermittent support from the primary mental health care team. In response to his deteriorating presentation, he was managed by way of an act, a process here operated as a crude risk reduction tool rather than as a forum for any informed clinical input. These serious shortfalls within his clinical care also inform the wider failure in his case to submit any report under Rule 35.1 or 2 throughout his detention at Brook House, despite his progressive worsening of his psychological symptoms and his ACT monitoring. And further still, D1713's continued detention in the face of his evident vulnerability illustrates the persistent failure of the Home Office to correctly apply its own adults at risk safeguards. The detention reviews carried out throughout his time at Brook House were premised on the erroneous, and it appears by route assessment, that he had no medical conditions and did not engage the adults at risk policy at all. There was an entrenched failure, if not refusal, to have regard to the extensive evidence of his risk factors, which the Home Office were, or ought to have been apprised of, and constituted at the very least adults at risk level 2 evidence. Whilst he was at Brook House, D1713 was also exposed to the general atmosphere of fear and institutional indifference created by the staff. He was subjected to demeaning and bullying treatment by officers, including an incident that's already been referred to when, during nighttime lockup, the period when he struggled most with his traumatic flashbacks, he asked a DCO if she would lock up her dog, like she did him, to which she responded, "I would never lock up my dog, but I would lock you up." This comment left D1713 feeling both shocked and humiliated. He felt the comment to have racist undertones, in line with the generally more oppressive attitudes he had seen staff demonstrate towards detainees of Black, African, and Middle Eastern origins. This exchange also reflects some of the evidence you've already heard, and indeed seen, Chair, concerning the dehumanising dimension to the staff abuse at Brook House, detainees being reduced to feeling like caged animals or becoming objects of the officers' macabre entertainment. Mr. Goodman touched on this yesterday with regards to his client, D1527, and cited specifically this incident concerning D1713. And it is noteworthy that there are several references within D1713's contemporaneous medical records which refer to him stating that he felt he was being treated or made to feel like a dog whilst at Brook House. And he echoes this within his witness statement, which is before you, Chair, already, stating that the experience of lockup made him feel, and his fellow detainees, like animals. It is an apt analogy to help this inquiry appreciate the extreme psychological debasement that many of these detainees faced by staff. D1713 also witnessed several incidents of highly vulnerable detainees, either self-harming or in clear mental distress, being subjected to inappropriate and heavy-handed restraint interventions by staff, and he believed at least one of those vulnerable detainees to be relocated to the CSU. He also speaks to the climate of staff impunity at Brook House, saying in his witness statement that he and his fellow detainees were too scared of reporting any concerning incidents they witnessed in case of reprisal by the officers or being taken to the block. These aspects of both overt and insidious abuse at Brook House must of course be considered with specific reference to his particular vulnerabilities. In his case, as a highly vulnerable individual whose history of torture and serious mental health needs were simply not identified, let alone addressed at Brook House. It is the interplay of those failings of the Rule 35 safeguards, clinical care, together with this punitive staff culture, which operated to produce the conditions of acute distress and mental suffering which he is, even now, still seeking to recover from. Chair, if I may then turn to the fifth and the final of the Bat-Murphy non-state core participants, this is D1473. He is a Nigerian national who was detained at Brook House for a single period of time from the 19th of August to the 29th of September 2017. Prior to this, he'd been detained at the Verne from the 13th of July until his transfer to Brook House. His experiences at Brook House are framed by the highly distressing mistreatment he suffered early on in his admission, where he was subjected to prolonged and excessive restraint by way of a waist restraint belt in the context of a wrongful and unlawful attempted removal. D1473 is a victim of horrific and repeated torture, which included beatings, sexual assault, being stabbed and stripped. He came to the UK on a visits visa. He was detained at the Verne for several months in late 2014 following the expiry of a custodial sentence. He then applied for asylum at around this time, but was ultimately unsuccessful. D1437 was then served with a deport order in April of 2015. He was then detained at the Verne on the 13th of July 2017 before his transfer to Brook House on the 19th of August. It is important first to appreciate the context of his known vulnerabilities on admission to Brook House. On arrival there, D1473 already presented as an intensely vulnerable individual. He arrived on an open act and was placed on constant watch and transferred to E-Wing very shortly after, having expressed suicidal thoughts linked to being behind locked doors. Whilst at the Verne, D1473 received a Rule 35-3 report, which confirmed that he may be a victim of torture with consistent physical and psychological symptoms which may continue to worsen in detention. He disclosed in that assessment suffering flashbacks which had worsened in detention due to the provoking factors of, for example, hearing keys in doors. However, notwithstanding this, the Home Office unjustifiably maintained his suspension, despite accepting that he was an adults at risk level 3 on the basis of his claimed risk of reoffending, despite him plainly not presenting as a significant public protection concern so as to justify the exceptionality of his ongoing detention. This adults at risk level 3 was then inappropriately downgraded further to an adults at risk level 2 grading whilst he was at Brook House. It seems on the basis of information from healthcare that further detention was in fact not injurious to his health and that his mental health appeared to be well managed. There had, though, been no positive change to the clinical picture of risk from the original Rule 35 report. D1473's state had in fact deteriorated further during his time at Brook House, accelerated by the Restraint incident, and he still had yet to receive any psychiatric input. His detention was therefore maintained on the basis of this further and serious misapplication of the adults at risk policy. Moving, though, to his index Restraint incident, D1473 was only told on the evening of the 23rd of August 2017 that he would be removed on a charter flight that evening, with Taskor contracted at the time by the Home Office to manage those escorts. This news caused him serious shock and distress, as he had outstanding Article 8 representations at the time, which had only been made a week before and had yet to be determined by the Home Office. He sought to inform the detention and Taskor staff of this, both prior to and during this restrained escort, however he was simply ignored. D1437 was in fact entirely correct in his assertion that he could not be removed. This was for various reasons, but most significantly that he had outstanding further submissions which in themselves operated as a legal bar against his removal. The fact that he knew he was being wrongly removed and his protestations were unheeded served only to exacerbate the trauma and insult of being unjustifiably restrained for such a very long period of time. He did not, however, resist or become non-compliant on being told of his removal, but notwithstanding this, he was placed by the Taskor officers in a waist restraint belt with both of his hands tied to the belt. He was then transferred to the airport in this belt still. He requested several times during this escort that the belt be loosened as it was causing him discomfort. The officers refused to do so. This waist restraint belt was finally removed only at the airport when he was told that he would not be removed and would in fact be returned to Brook House. In total, he had been restrained in the waist restraint belt for a period of 5.5 hours. On his return to Brook House, he was placed back in E-Wing and back on Act observations. It is eminently clear that this restraint, which was initiated on Brook House premises by Home Office contractors, was unjustified and unlawful. As became clear in the subsequent complaints and indeed litigation process pursued against Taskor, there was no individualised risk assessment, nor prior authority with respect to the application of this restraint on D1437, as is necessary for planned cases of restraint in line with the DSO 07/2016 policy on restraints for escorted moves. Nor was there any justification for the use of spontaneous force in this incident to effect his transfer. The DSO again advises that only in a, quote, reactive situation, such as one of medical emergency or urgent situations following sudden disruptive behaviour, can a DCO authorise their own restraint, premised on a dynamic risk assessment. D1437 was not resisting or showing any signs of aggression, nor did he have any positive risk indicators of violence or disruptive behaviour which, taken together with a refractory presentation, may be taken to justify the use of some restraint, though not to the level imposed here. In any event, the application of such extreme and prolonged force is not only wholly inappropriate, but entirely contraindicative to the management of clinically vulnerable detainees, such as D1437, who are at heightened risk of suffering from the feelings of inferiority, humiliation and mental distress consequent to restraint and indeed to detention in general. This distress was further compounded in his case by his demeaning treatment by the officers during the escort. This included them laughing at him during the move when he passed gas, owing to the tightness of the waist restraint belt, which they had refused to loosen, and on arrival at the airport being forced to use the toilet while still in his belts, his arms still severely restricted under the watch of 2 officers. It was not surprising then that D1473, an already recognised level 3 adult at risk individual, suffered a serious deterioration in his mental state following this restraint. He reported to healthcare on numerous occasions, feeling traumatised by the incident, and that it had precipitated a worsening of his traumatic symptoms. Despite this, again though, no referral was made for him to receive specialist mental health support. In the circumstances, the prolonged restraint of D1473 by way of a waist restraint belt constituted inhuman and degrading treatment contrary to Article 3. This reflects the specifically aggravating effect of such a prolonged restrictive measure on his already vulnerable and at-risk profile. However, even if he was not suffering from these particular vulnerabilities, the use of such extreme restrictive force in cases short of exceptional risk would, we say, still likely reach that Article 3 threshold of mistreatment. And I would refer, Chair, in this regard to the findings of the report prepared by the advisory panel of the non-compliance management, which was chaired by Shaw. It's a report from March 2014, which was tasked to assess a new syllabus for restraint techniques for escorted removals following the death of Jimmy Mabenga. The panel raised serious concerns there over the potential misuse of waist restraint belts and restraint equipment in general, finding that, quote, the long-term use of the belt, in particular in circumstances which would expose the subject to the public, would be inimical to the subject's dignity and potentially to his or her right not to be subject to inhuman or degrading treatment. It also needs to be said that D1473's search for accountability in respect to the circumstances of his restraint and unlawful attempted removal remains ongoing. The subsequent PSU investigation into the circumstances of this restraint was wholly inadequate, dismissing the complaint on the basis of a claimed history of disruptive behaviour and self-harm risk. That was notwithstanding that it was accepted by the PSU that D1473 had in fact been compliant during the escort, as was shown on the CCTV. The PSU failed entirely to grapple with the primary question of the actual and contemporaneous rationale for the prolonged application of restraint, or indeed its appropriateness in relation to an acutely vulnerable individual. Similarly, a complaint made to the Detention Services Unit concerning D1473's unlawful removal arising from that same incident was not upheld on equally unsatisfactory grounds. Private law proceedings were subsequently issued against Taskell for assault and breaches of Article 3 concerning his restraint. Parallel judicial review proceedings were brought concerning the lawfulness of this removal and underlying detention. Both claims, however, were compromised early on, the Home Office at the pre-action stage, and both by way of pecuniary compensation only. There was no admission of liability, there was no explanation, and there was no apology from either the Home Office or Taskell for their actions. D1473's legal representatives have also been asking since the PSU process for disclosure of the CCTV in relation to this incident, which is referred to in the PSU report. These requests were renewed and refused in the civil litigation, and years on, this material has yet to be provided. This, of course, fundamentally limits the ability of D1473 and his representatives to gain a full understanding of the events so many years ago now, and to put that before the inquiry today. It also begs the question of why these institutions have refused to provide this key material, especially where the corollary is that his legal representatives are left with no other option but to force this issue into the public domain in order to try and compel that disclosure. It is hoped, Chair, that through this inquiry, D1473 may finally see some form of accountability for these events. However, he welcomes this inquiry not simply to understand what went so badly wrong at Brook House at that time and why, but also in the spirit of genuine and concerted progress to ensure that meaningful recommendations are made and indeed acted upon by both the Home Office and its contractors that will prevent the recurrence of the multiple and serious forms of mistreatment that D1473 and D1713 and so many other detained persons suffered at Brook House and indeed across the detention estate more widely. Thank you, Chair.
I understand that we will now be hearing from Mr. Stanton.
Yes, thank you, Chair. I understand there's to be a fire alarm test at 10 o'clock, and as that's three minutes or so away, it might be worth waiting until that's taken place.
I think that is a very good idea. Yes, let's take a 5-minute break and come back just after 10 o'clock.
Thank you.
Thank you.
Thank you,
Mr.
Chair.
Sanson, thank you.
This is the opening statement on behalf of Owen Syrah. Mr. Syrah is in attendance today and sat beside me. Mr. Syrah is grateful for the opportunity to participate in the inquiry. His aim in doing so is to tell you what the conditions and the culture at Brook House were really like on the ground from the perspective of an experienced detention custody officer. He worked at Brook House for over 11 years, between 2009 and 2021. In the first part of his career, he spent several years on C Wing, 9 months on E Wing, and he also worked as a family care officer at Tinsley House. Later in 2016, Mr. Syrah became a welfare officer, and while in this role, he spent 5 months on secondment to the Home Office, working on a pilot for voluntary removals, which proved to be very successful. Mr. Syrah's firm belief is that the primary role and responsibility of a detention custody officer and manager is to ensure the welfare of detained persons. And while at Brook House, he became accredited as an assessor for assessment, care and detention and teamwork, commonly referred to as ACDT, through which process detained persons at risk of self-harm are assessed and managed. He also gained accreditation as a safer custody trainer, in which capacity he provided training to colleagues on issues of mental health, bullying, de-escalation techniques, and the ACDT process. In Mr. Syrah's experience, the panorama footage is not representative of how all staff behaved. Many staff at Brook House treated people who were detained with friendliness, dignity, and compassion. That said, the Panorama programme shone a light on aspects of staff behaviour which were wholly unacceptable, and Mr. Syrah welcomes the inquiry's scrutiny of the behaviours and culture at Brook House, which are issues that have concerned him for many years. Mr. Syrah's hope is that the work of the inquiry will lead to significant change and improvement for both people who are detained and for the people who work within detention centres. Mr. Syrah's range and wealth of experience make him ideally positioned to contribute to the inquiry's work, in particular by highlighting the methods, policies, practices and management arrangements at both the Home Office and G4S that may have caused or contributed to the mistreatment of detained persons, and to suggest options for improvement in these areas. Mr. Syrah has provided a lengthy statement to the inquiry, and he looks forward to giving oral evidence later in this hearing session. For now, in this opening statement, he wishes to highlight the following 5 key issues, which it is hoped will assist the inquiry team and other core participants. First, the prevalence of an us and them culture. Mr. Syrah's approach to working at Brook House was to seek to engage with detained persons and to build positive personal relationships. Brook House is far from a normal working environment, and as a wing officer, you had to live and work alongside over 100 detained persons for 14 hours a day, sometimes longer. It could be a volatile and at times threatening environment. Mr. Syrah took time to chat with people who were detained over a coffee, to share a joke with them, and he learned how to say hello in numerous different languages to help break the ice and demonstrate a friendly attitude. However, in doing so, he repeatedly faced accusations from colleagues that he cared more about detained persons than he did about staff. He was referred to by some members of staff as a, quote, traitor, close quote, and as someone who was, quote, all for the detainees and not for the staff, close quote. On one occasion, when he was taking his lunch with people who were detained, a colleague asked him, quote, why are you sitting with these animals, close quote. The culture was very much one of staff sticking together and that you don't grass on your colleagues. Mr. Syrah recognises that the working conditions at Brook House were difficult there was chronic understaffing and a lack of experienced staff due to high staff turnover. Staff regularly faced verbal abuse and sometimes physical violence. However, not enough was done by management to combat the us and them tendency, and officers who spoke out about the treatment of detained persons were ostracised and left isolated and unsupported. When in 2014, Mr. Syrah reported an incident of racist behaviour by a colleague, he was subjected to a campaign of bullying and intimidation by colleagues for over a year. This included leaving post-it notes on his locker stating that he was a grass and other notes that contained offensive racist language. Mr. Syrah was warned by a colleague that some staff had it in for him because he'd made the report and that his movements and actions within the centre were being monitored on CCTV. False complaints were also made against him, and it became so intolerable that Mr. Syrah had to take time off work due to stress. When these are the consequences of speaking up against inappropriate behaviour, it's not surprising that staff were so reluctant to do so. An illustration of the adverse impact on the welfare of detained persons from staff feeling unable to speak up is provided by the following incident. In the spring of 2017, Mr. Syrah was assaulted by a detained person, and the first response team was called. By the time the first response team arrived, the detained person was already restrained and under control. However, a member of the first response team punched the detained person while he was still restrained. Mr. Syrah did not report the incident, and he regrets not doing so. However, he was reluctant because of the prolonged bullying and harassment he had experienced 3 years earlier. There were two types of officer: those who treated the role as a career and wanted to do their best, as Mr. Syrah did, and those who did the bare minimum and sometimes not even that. If you cared about the welfare of detained persons and wanted to improve conditions within the centre, it could burn you out because you assumed responsibility that others did not. Many officers made no attempt to assist detained persons, and as a result, they, the detained persons, would approach members of staff that they knew would try and help, for example, with queries about an immigration document or if they needed help fixing something in their room. Because of this difference in approach between staff, those officers who tried to help became overwhelmed with queries from detained persons. The introductory and refresher training for staff should have included more on team building and teamwork to emphasise the benefits of being open to different views and approaches. The training could also have done more to build an awareness and understanding of the circumstances of those who were detained, which would have helped some staff to see them more as people and mitigated against an us and them culture. Second, the prevalence of a laddish culture and the influence of peer pressure. For some staff, planned interventions and the use of force were the only occasions that they showed any enthusiasm. They were just there for the thrill of the fight. During the introductory training course, staff were given the impression that control and restraint was the most important aspect of the training, and there were colleagues who were almost too enthusiastic about the control and restraint training. Once on the wing, becoming involved in a control and restraint exercise was treated as a rite of passage, and some officers were too quick to deploy the use of force rather than engage with detained persons and seek to de-escalate the situation. Brook House was a very cliquey environment, and some of the managers were far too close to the officers within their social circles. This led to a culture where inappropriate behaviour was not challenged. Some staff became empowered to behave abusively because they knew or believed that there would be no consequences to their actions. Senior managers were not visible on the shop floor, and some deputy directors disparaged attempts to build positive relationships with detained persons, which had a negative impact on life within the centre. It affected the way staff engaged with detained persons and with each other and created a pressure to go with the pack. If you didn't conform to what others believed the role of an officer should be, you were ostracised. And this had a powerful effect on staff attitudes and behaviours. Some staff tried to hide their lack of confidence and assurance with bravado. Others acted out of character just to fit in. There are examples of this type of behaviour in the Panorama programme, which Mr. Syrah has highlighted in his witness statement. Suggestions for improvement in this area are additional training on conflict resolution and improved recruitment to ensure that people with the necessary skills are recruited. This is dealt with in more detail in the next section. Third, staff recruitment, retention and shortages. There has always been a high turnover of staff at Brook House, and Mr. Syrah believes that the reasons for this are the failure to recruit enough people interested in the job as a long-term career, the lack of recognition and reward for experience in the role, and the stresses of the job. The role as advertised was entirely unrepresentative of the reality of the situation. New recruits weren't told about the levels of hostility, the violence and self-harm, or about the difficulties with staff shortages and morale. A lot of staff left very quickly after starting because the reality of the job was not as it had been described, and this put pressure on the organisation in terms of staffing levels, as well as wasting resources by training people who were not the right fit. Each of A, C and D wings accommodated around 135 detained persons over 3 levels, and it was a requirement that there should be at least 2 officers on a wing. However, Mr. Syrah once worked 3 consecutive days on his own on C wing due to staff shortages. Staff felt overwhelmed, and they did not have time to do their job properly and give individual attention to detained persons. Staff also felt undervalued and that management were not listening. Staff needed to be hyper-vigilant to respond to drug misuse, violence and threatening behaviour, and this caused mental health problems for some. Mr. Syrah would finish his shifts absolutely worn out and grateful that he was unharmed, especially in the early days. Staff shortages also contributed to disruptive behaviour in the centre and negatively impacted on the welfare of detained persons, including their mental health, because of a lack of activities and a lack of staff who were available to listen and engage one-to-one. It went in cycles. There would be a recruitment drive and new staff would arrive, but quite quickly large numbers of staff would leave. There was never a period when there was prolonged stability. It has always been a significant problem, and the need for such frequent recruitment and introductory training was and is a huge drain on already stretched resources. In Mr. Syrah's view, it would be far better to have a more rigorous recruitment process with greater emphasis on identifying committed candidates who wish to pursue and build a career in this field of work. A further much needed improvement that would assist with retention of quality staff would be to introduce a form of career progression within the grade of detention custody officer, so that experienced officers can be rewarded for doing a good job and regarded as a profession, supported with a professional qualification such as an NVQ in custodial settings. To run Brook House effectively, it needs experienced, committed professional officers, and the existing recruitment policies and procedures and the high turnover of staff mitigate against this. Fourth, high levels of mental illness and recreational drug use. Mr. Syrah is not qualified to diagnose mental health conditions. However, he has received training on mental health issues. He is an accredited ACDT assessor, and he is also accredited to deliver training on mental health issues. In his estimation, there were significant numbers of detained persons at Brook House who are suffering from severe and moderate mental health issues, which is unsurprising given the situation and backgrounds of many of the detained persons. Further, Mr. Syrah estimates that somewhere in the region of 50% of detained persons were taking drugs recreationally. They were bored stiff because there was so little to engage them. The drugs were a form of escapism and a coping mechanism. Drugs impacted significantly on the mental health and safety of detained persons. Their side effects caused anxiety, depression and psychosis. Detained persons engaged in reckless behaviour while under the influence of drugs. There was violence to control supply, and there was worry over drug debts. There was undoubtedly a pervasive and very damaging drug culture within the centre. Mental illness was a cause of self-harm. However, self-harm could also be triggered by issues such as lost property, the cancellation of a flight, or an adverse immigration decision. Some detained persons felt so desperate, and it was important to help them by encouraging and talking to them so they could come to a better state of mind. For some staff, this wasn't a priority, but more generally, staff simply were not equipped to deal with the large number of people who were experiencing these issues. And in addition to the risks to detained persons, this contributed to low staff morale and retention. Officers who worked on E-Wing, which is where much of the Panorama programme was filmed, were particularly exposed to these issues. Brook House was never designed to be the long-term holding facility that it became for some detained persons. The building is not big enough, and yet steps were taken to increase capacity. It would benefit from the availability of more activities to avoid boredom and provide detained persons with some sense of purpose, and from improved social areas, such as a coffee shop, where both detained persons and staff can socialise and integrate. In general, any steps to reduce the feeling of a prison would be beneficial. One specific suggestion for improvement is better communication by the Home Office with detained persons about the status of their immigration cases, because they often feel in limbo, which negatively impacts their mental health. If immigration applications and appeals were processed quicker and detained persons were updated more regularly on their progress, this would reduce their levels of anxiety. Home Office caseworkers could also be educated about the practical impact of casework delays on the people who are being detained pending their outcome. Fifth, positive behaviours and improvements. When Brook House first opened in 2009, it was a dreadful place. 90% of the people who were detained were time-served foreign national offenders, and it was rife with drugs. There were also problems with prostitution, bullying and gambling. Just before Mr. Syrah started work as an officer, there was a riot on A-Wing, and a specialist prison service team, the Advanced Control and Restraint team, had to be called to deal with the incident. Fights would break out amongst detained persons and between detained persons and staff. Feces were thrown at officers. It was a very menacing and tense atmosphere. The events depicted on the Panorama programme were shocking and have quite rightly resulted in this inquiry. However, by 2017, there had already been a number of improvements at Brook House, such as the ACDT process, which was much more robust and seen as an integral and effective tool for ensuring the welfare of detained persons, better activity programmes, and improved security measures within the centre, such as restricting detained persons to the wings in which they were resident. Following Panorama, this process of improvement was escalated. Staff who had been there the longest and who cared about the role were listened to more by both senior management, the Home Office and other colleagues. Some of the improvements made were to increase staffing, including in welfare and healthcare, increased emphasis on activities, the introduction of the Forward Trust for Drug Counselling, more comprehensive training, and better communication and collaboration among the staff, particularly between officers and managers and the healthcare team. The Panorama programme also made staff much more aware of their own behaviour, with the knowledge that they were subject to scrutiny. Prior to working at Brook House, Mr. Syrah had a career in construction management, and he has significant experience of different working environments and practices. Despite all the difficulties and challenges at Brook House and the shocking behaviour of some staff, he has never had such admiration for the people he worked with. And there were and are a significant number of Brook House staff, like Mr. Syrah, who seek to treat detained persons with decency, dignity, friendship and compassion. Thank you, Chair.
Thank you, Mr. Stanton. Mr. Blake. Oh. Let's go ahead. My apologies.
Is that working now? Thank you. Chair, the BBC is the nation's public service broadcaster. It is impartial and independent. It aims to inform, educate and entertain millions of people in the UK and around the world. Panorama is a current affairs documentary programme, as you've heard, which has been broadcast on BBC television since 1953. It's well known for its investigative journalism and it's well known for revealing public interest stories. The BBC and the Panorama team are both subject to strict editorial guidelines. The BBC was established by Royal Charter in 1926, and its most recent Royal Charter sets out the BBC's public purposes and defines the activities that may be carried out by it. Those activities include, at Article 6, providing duly accurate and impartial news, current affairs and factual programme, which should be provided to the highest editorial standards. Article 3 of the Charter also makes it clear that the BBC must be independent in all matters concerning the fulfilment of its mission and the promotion of its public purposes, including as regards editorial and creative decisions. The Royal Charter is of course supplemented by editorial guidelines which impose similarly high standards of due accuracy and due impartiality. Chair, as you have heard, on the 12th of January 2016, the BBC Panorama team received an email from an officer at Brook House called Callum Tully. He was then 19 years old. He had been employed with G4S from January 2015, working mainly at Brook House. His email raised serious concerns about the culture and conduct of staff at Brook House. The Panorama team contacted Callum Tully and over a period of around 14 months communicated regularly with him. Callum Tully provided his impressions of work at Brook House. On the 6th of March 2017, Callum Tully began his employment at the BBC, working under the supervision of a senior producer in Panorama. Between March and April, he completed a period of specialist training with the BBC to prepare him for secret filming. The BBC provided Callum Tully with a protocol on undercover filming so as to ensure that any undercover filming he carried out was carried out in a responsible and proportionate way. Callum Tully then filmed, as you have heard, undercover in Brook House between April and July 2017. You have seen some of the footage that he filmed. That footage revealed further serious concerns about staff conduct at Brook House, including as regards the use of force, the use of derogatory language about detainees, and about the prevalence of self-harm and drug use amongst detainees. You may consider, Chair, that the footage is entirely consistent with Callum Tully's description of life in Brook House. And the result of that filming was an episode of Panorama, Undercover Britain's Immigration Secrets, which, as you've heard, was broadcast on the 4th of September that year. And that documentary, Chair, is an example of the accurate, impartial and informative programme that is required under the Royal Charter and the BBC's editorial guidelines. The instances of abuse and mistreatment revealed by that programme are now the subject of investigation in this inquiry. The BBC is committed to assisting you, Chair, in exploring the important issues that its programme brought to life. And you may consider, Chair, as you explore those issues, that the footage filmed by Callum Tully speaks for itself. Thank you, Chair.
Thank you, Mr. Bunting. I believe we're now going to hear from you, Mr. Dixie, on behalf of the Independent Monitoring Board.
Chair, good morning. I, along with Ms Wright, appear on behalf of the Independent Monitoring Boards, or IMBs. We're grateful for the opportunity of making this short opening statement. If I may, I will briefly explain who the IMBs are and the role performed by them within immigration removal centres such as Brook House and other institutional settings. As you may recall from our application for core participant status, there is no single independent monitoring board, although I anticipate that we will all, myself included, refer to the IMB in the singular rather than the plural. Members of the Brook House IMB, like all members of the IMBs for immigration removal centres, are appointed by the Secretary of State pursuant to Section 152 of the Immigration and Asylum Act of 1999. That legislation refers to visiting committees. Board members are unpaid public appointees. They are appointed for 3 yearly terms, renewable for a maximum of 15 years. Each board elects a chair and vice chair who are approved by the Secretary of State. During the relevant period, there were 9 members of the Brook House IMB. IMBs are independent of the Home Office and other organisations, including the IRC contractors. Each board is a separate statutory entity, although in practice local boards and their members are guided and supported by national governance arrangements agreed with the relevant ministers. Those national governance arrangements now consist of a national chair and management board for all IMBs. As you will hear in due course from the current national chair, Dame Anne Owers, during the relevant period for your inquiry, those national governance structures were significantly different. IMB members play an important role within immigration removal centres. They must satisfy themselves as to the conditions and treatment of the detained persons. They must report to the Secretary of State annually and immediately if they find abuse. To that end, they are afforded access to speak privately to all detained individuals and see most documents held in the removal centre. They hear complaints and requests from detained individuals. Boards do not have a regulatory role. They can alert managers to problems and can offer advice and recommendations to the centre, the Home Office or the Minister. However, they are not responsible for running the centre or the oversight of contractual responsibilities. They can only alert those who are responsible and the Minister to any concerns. The IMB welcomes this inquiry. It offers an opportunity for detained persons, formerly detained persons, to speak openly about their experiences whilst at Brook House. It is right that in this first phase of your inquiry, you will hear evidence from former detained persons. Their evidence must be at the heart of this process. You will hear about the abuse which they have suffered. This has been outlined already by counsel to the inquiry and those representing the interests of some of the former detained persons. The abuse revealed by the BBC's undercover reporter was reprehensible. You will also examine the complaints and monitoring processes at Brook House and the role which the IMB played in them. These mechanisms will be subject to careful scrutiny. We anticipate you will seek to understand what barriers may prevent abuse and mistreatment from being reported. This inquiry presents a real opportunity to learn from the experiences of those former detained individuals and to improve the system for the future. We, the legal team representing the IMB, will attend these proceedings throughout. Members of the IMB mean no discourtesy to you or to those who have been mistreated by not attending in person for the duration of the hearings. Consistent with your operational arrangements, we have limited the number of people who are physically in attendance. However, IMB members are observing these proceedings remotely and will continue to do so. They will watch and listen to the testimony of those former detained individuals who have bravely come forward to give their accounts. The IMB is committed to reflecting upon that evidence and to further improving its processes to better meet its responsibilities to those within immigration detention. As I have said, the IMB welcomes this inquiry and has made good that sentiment by disclosing to you a significant amount of material. To date, the IMB has disclosed to the inquiry many hundreds of pages of documents in response to requests made of it. A statement has been provided by the National Chair for the purpose of explaining the IMB's role and reflecting on the mistreatment which was exposed in the BBC's Panorama programme. The IMB is committed to assisting you and your team in the vital work which lies ahead. it is a significant and important undertaking. Thank you.
Thank you very much, Mr. Dixie. Mr. Blake, we can either break now. I believe that you anticipate speaking for about 20 minutes.
Yes, I'd appreciate it very much to steal Mr. Bunting's lecture.
Let's do that. So we will return at, we will take our 30-minute longer break now. So we'll return at 11 o'clock. Thank you very much. you. Mr. Blank.
Thank you very much, Chair. I appear on behalf of the Home Office together with Miss Wilsden and Miss Hancock. The Panorama documentary showed footage which the Home Office has, from the very beginning, made clear is unacceptable. As Mr. Altman noted in his opening, when it was broadcast, the then Immigration Minister quite rightly said that it was appalling. In fact, even before it was broadcast, the Home Office had suspended the certification of 9 G4S officers, and 3 more had their certification suspended soon after, meaning that they couldn't work in a custodial environment. Several were quite rightly dismissed by G4S. Independent inquiries were instigated, including expanding the review by the former Ombudsman Stephen Shaw and the commissioning by G4S of their own inquiry by Kate Lampard. They both reached important conclusions. PSU investigations were also instigated. Your own non-statutory inquiry was instigated by the Home Office. The terms of reference focused on Brook House were not themselves subject to challenge. This statutory inquiry will, in due course, confront those former G4S officers who are shown in the footage and any other individuals who are accused of mistreating those who were detained at Brook House during the relevant period. The High Court ordered the statutory inquiry so that those former G4S officers, such as those we saw on the screens yesterday and the day before, could be confronted by their victims. We heard on Tuesday that some of those officers who were dismissed, quite rightly, will be compelled to give evidence under Section 12 of the Inquiries Act to account for their actions. The individual victims, rather than broad political arguments, need to be at the heart of this inquiry. And the victims must have every opportunity, where possible, to give their oral evidence, whether in Phase 1 or Phase 2, with special measures where appropriate to assist them. The ultimate achievements of this inquiry will be both to hold the abusing former officers to account and to ensure that this doesn't happen again. These hearings are being followed remotely, and the evidence that's given to the inquiry will be listened to carefully, and the Home Office looks forward to considering the report in due course. The inquiry's been instigated and has been investigating Brook House for over 2 years, even longer in its non-statutory form. And the Home Office wishes to acknowledge the painstaking process that has been undertaken and the public cost in doing so. The Home Office has done all it can to assist this inquiry in its thorough investigation and will continue to do so. We've provided disclosure of almost 35,000 documents, provided detailed witness statements from 8 witnesses, detailed explanations of procedures and processes, and responded to other information requests. And we continue to assist, having very recently received requests for statements from 7 further individuals, and just a few days ago, a very detailed request for video footage. No doubt other core participants have also been providing significant assistance over the period and will continue to do so. What the inquiry will undoubtedly hear from the Home Office in due course are 2 things. First, you'll hear from committed civil servants who worked incredibly hard dealing with issues relating to immigration enforcement. You'll hear from a range of dedicated, knowledgeable, and caring individuals from the Home Office who had to navigate difficult and complex issues. Second, you'll hear about the significant improvements that have been put in place since the Panorama broadcast. The broadcast took place 4 years ago, and there's been an ambitious programme of reform since then. It's easy to place the blame on obviously political topics, the numbers of people who, by virtue of the immigration laws and rules, have to leave the country or have to be detained, or the length of detention, which is a matter that's carefully regulated by the courts and which has been incorrectly characterised as indefinite, none of which are within the scope of this inquiry. But the improvements that were required at Brook House are actually more mundane, principally contractual matters. They concern the numbers of staff employed by contractors improvements in staff's professional skills, improving whistleblowing procedures, and sanctions to penalise contractors appropriately for poor performance. They concern performance management and assurance, and you'll hear about how these issues were remedied, in particular when the Home Office changed supplier and entered into a new contract with Serco, a contract that needed careful consideration before it was agreed and which couldn't be entered into overnight. Improvements continue to be made, and we're grateful to Mr. Syrah today for recognising that improvements have been made. Some of those who spoke yesterday have called for fundamental and radical or bold proposals by the inquiry. And there's obviously a natural temptation to do this because it's a big inquiry. Millions of pounds have been spent with years of preparation and many weeks of hearings. But we asked the inquiry to consider the circumstances of the particular mistreatment at Brook House, where it is found, and the changes that have occurred since the broadcast. An inquiry that makes focused but important findings and recommendations is just as valuable, just as relevant, in fact more so, to the well-being of those who are detained, as one that makes bold but unrealistic proposals such as ending immigration detention or other grand political proposals that we heard suggested yesterday. We stand by, ready to listen to the evidence, to see what further changes will help the Home Office meet its important priorities of safeguarding the vulnerable and ensuring that everybody is treated with dignity in a detention estate that is fit for purpose. Thank you very much.
Thank you, Mr. Blake. Ms. Mannion, I'll give you a moment.
I'm actually going to turn down the high-stakes manoeuvre to receive the, in favour of the trustee box.
Okay, sounds good to me.
Chair, with Mr Metzer, I represent Her Majesty's Inspectorate of Prisons, which I'll be referring to as HMIP. I'm going to say a few words about HMIP, its remit, how its inspections work, what inspections achieve, and what their limits are. Before that, however, I wish to make clear that HMIP is committed to assisting this inquiry with its important work. HMIP recognises that the inquiry will wish to examine the effectiveness of oversight mechanisms designed to detect mistreatment, of which HMIP forms part, and also the effectiveness of improvements that HMIP has already made to its inspection methodology since 2016. HMIP will cooperate fully with this inquiry in pursuit of effective conclusions. Chair, HMIP is an independent inspection body led by Her Majesty's Chief Inspector of Prisons. The Chief Inspector has statutory duties, which include the duties to inspect immigration removal centres and to report to the Home Secretary on the treatment of detained persons and conditions in removal centres. HMIP forms part of the United Kingdom's National Preventative Mechanism, the NPM. The NPM is a group of 21 inspection, monitoring and visiting bodies designated by government under the United Nations Optional Protocol to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, OPCAT, to carry out regular visits to places of detention. OPCAT recognises the important role that regular independent visits to places of detention play as part of a wider system designed to prevent torture and other ill treatment. As you are aware, HMIP carried out an unannounced inspection of Brook House Immigration Removal Centre between the 31st of October and the 11th of November in 2016. That led to an inspection report which was published on the 10th of March 2017. That report has been, no doubt, and certainly will be considered by you in some detail. At this stage, it's necessary to say that whilst the report identified some poor practices and recommended improvements, it did not uncover a pattern of incidents of the type seen in the Panorama documentary. The HMIP inspection took place some 5 months before the footage seen in Panorama was filmed. HMIP was extremely concerned by the footage, excuse me, and immediately reviewed whether indicators of abuse had been missed in 2016, and also whether changes to its methodology might assist it better in identifying individual instances of mistreatment or systemic risks. That self-reflection led to the implementation of an enhanced methodology in all inspections of immigration removal centres. That change was in place by October 2017 and has remained in place since, subject only to temporary modifications as a result of the pandemic. An enhanced methodology would only previously have been used where there were specific indicators of a particular risk. You will, I know, examine this enhanced methodology alongside the many robust inspection procedures which were already in place in 2016, which that enhanced methodology complements. As to what was already in place, since 2013, HMIP has operated an almost entirely unannounced inspection programme. Immigration removal centres like Brook House are inspected at least once every 4 years, and most can be expected to be visited at least every 2 to 3 years. The aim is for inspection timing to be unpredictable, and the exact timing is based on intelligence and risk assessment. Unannounced inspections are designed to help inspectors see things as they really are, and the inspectorate's highly skilled team are trained to look behind what is on show. The HMIP inspection team carries its own keys and has access to the entire establishment throughout the inspection. In 2016, as now, inspectors use 5 key sources of evidence: observation, contact with detained persons, staff, and relevant third parties, and documentation. Evidence is tested rigorously to check whether it is corroborated and supported by other sources, to try to ensure that the assessment is as valid as possible. That process is known as triangulation. The focus of an inspection is on outcomes for detained persons rather than, for example, the level of a management's compliance with a particular policy. HMIP publishes its own inspection criteria, called expectations, which set out in considerable detail the outcomes that a, quote, healthy place of detention should achieve. The expectations look for outcomes, not processes or policies, and for best practice, not minimum standards. The enhanced methodology in use for all immigration removal centres from October 2017 is not wholesale change. Primarily, the enhancements are designed to encourage greater engagement and so obtain more information from detained persons, staff, and third-party organisations. First, it provides a greater opportunity for detained persons and staff to tell inspectors in confidence about the concerns they may have over safety or treatment. Every detained person is now offered an interview with an inspector using interpretation where needed. This opportunity is also extended to persons who were recently detained at the centre in question. All staff are now given the opportunity to respond to an anonymous survey that they can complete outside of the establishment, and where staff identify themselves, follow-up discussions and interviews may be arranged. NGOs are now proactively contacted by inspectors at the outset of inspections and expressly invited to contribute information and put detained persons they are in contact with in touch with HMIP inspectors. The enhanced methodology therefore provides many opportunities for the inspectors to identify potential concerns. The HMIP inspection team report on the evidence accrued in the ways that I have described during an intense inspection period. It's 2 weeks under the 2016 methodology and now 3 weeks under the enhanced methodology. Areas for improvement are identified and recommendations are made. These recommendations are based on the triangulated findings, but in addition to recommendations, information will also be given on matters which may require further investigation or follow-up by the Home Office or by the contractor. Thereafter, the Home Office is required to develop an action plan with input from the contractor as appropriate, setting out how the recommendations will be implemented or why they are not accepted. However, HMIP has no powers of enforcement in respect of its recommendations or the action plans made in response. The information and recommendations make clear the need for change and the direction of change, but the responsibility is on the Home Office or the contractor to take the appropriate steps. Turning to the value of inspections. Chair, in your consideration of inspection methodology, it is necessary to recognise what inspections are, their benefits but also their limitations. First, it is worth emphasising the distinction between inspection and other forms of external oversight. HMIP is not a regulator and does not seek enforcement or regulatory powers. A regulator can be limited to assessing can be limited to assessing compliance with guidance and rules set by the system it regulates, while the inspectorate is able to undertake a broader and detailed independent inspection of establishments. Likewise, HMIP does not carry out monitoring. Inspection and monitoring are both ways to provide independent scrutiny, but they offer different insights. Monitoring by volunteers is designed to provide regular insight to the day-to-day experience of those detained at an individual establishment. Inspection provides an in-depth and comprehensive view across all aspects of outcomes for detained persons in a place of detention at a particular time, and the benefits from the experience of professional inspectors who can compare and contrast from practice nationally. Finally, inspection is, of course, distinct from investigation, which takes place after an incident has occurred and examines individual cases in depth. I mentioned that HMIP does not have powers of enforcement. The Inspectorate works in a number of other ways to encourage authorities and establishments to accept and implement its recommendations. I will give you 4 examples. Firstly, by making sure that findings reached are well-founded, meaning establishments should have confidence in their accuracy. This is done by ensuring that the findings are triangulated, and there is also an ongoing dialogue between inspectors and managers throughout the course of the inspection, which allows responsible authorities to respond to emerging findings and provide other evidence, if they have it. Secondly, the Inspectorate not only highlights poor practice, but reports good practice in order to try to encourage establishments to learn from one another. Thirdly, each inspection will review and report on the progress against the recommendations made in the previous inspection. Fourthly, and importantly, inspections provide public accountability. By their nature, places of detention are not typically accessed by members of the public. Reports of inspections can alert the public and media to conditions in places of detention, which itself can be a powerful motivator for improvement. What are the benefits of inspections and how do they improve outcomes for detained persons? HMIP is independent and so is not caught up with what those running the place of detention or the system would like to think is happening. HMIP inspectors provide scrutiny based on criteria which are independent from the establishment and the system to evaluate from the outside. Inspections have particular value in drawing official and public attention to practices which may have come to seem normal in a detention setting, but which are not. Inspections can and do prevent harms by spotting problems and systemic issues before incidents occur, by encouraging improvements through sharing good practice, and through facilitating public accountability. It must be recognised, though, that inspections provide a snapshot derived from sudden, intense external scrutiny. There will always be particular challenges in identifying concealed practices. Inspections are not intended to replace proper management of the detention setting by whomever is responsible for running it, or supervision by those charged with oversight of day-to-day practices or operational considerations. Therefore, robust independent inspections must be seen as part of the means by which good practice is encouraged, implemented and maintained, and by which ill treatment is prevented, but not the only means. HMIP will continue to build on its existing good practices, its robust inspection methodology and the independent expectations which it sets. It will continue to make recommendations designed to ensure inspected establishments meet and maintain human rights standards and improve outcomes for detained persons. HMIP welcomes any opportunity this inquiry may afford to further develop the effectiveness of its inspections. HMIP also welcomes any opportunity to further develop its understanding of cultural or operational issues which put those detained at risk of abuse or ill treatment, or which impede the reporting of such abuse by those detained or by those who work in this field. Chair, I end as I began. As a constituent part of the framework that is designed to protect detained persons from the risk of abuse, HMIP is firmly committed to testing, refining and improving its methodology where appropriate. HMIP will actively participate in this inquiry, will listen with care to the evidence, and of course to any recommendations the inquiry may in due course make.
Thank you, Ms. Manning. Mr. Sharland?
Good morning, Chair. I act together with my junior, Mr. Daniel Eisenberg, for 2 core participants. Firstly, G4S Care and Justice UK Limited, and secondly, G4S Health Services UK Limited. The roles of Care and Justice and G4S Health at Brook House were distinct. They will each provide hopefully valuable input and evidence to the inquiry in relation to their experience and knowledge. This is why both entities have been given core participant status, although they both form part of the wider G4S group. However, there are certain aspects that are indeed common to both Care and Justice and G4S. First, both share the view, as expressed by Mr. Jerry Petherick, then Managing Director of CGS on the 4th of September 2017, that the conduct that occurred at Brook House, as shown on the Panorama programme, was completely unacceptable. That view is not caveated, it is not glossed. There are no ifs or buts. Unacceptable conduct took place, carried out by individuals who were, at the time, employed by G4S. G4S were not aware at the time of the misconduct that was taking place. If it had been, as Peter Nedden told the Home Affairs Select Committee, it would have taken action. That may be of little comfort to those detained persons who suffered at the hands of G4S employees, and for that, the company expresses its sincere and deep regret. As Mr. Nedden said, he, on behalf of the company, was both ashamed and sorry for what he had seen on Panorama. Secondly, both Care and Justice and G4S Health are fully supportive of the work of the inquiry and its aims, and will do what it can to assist it. That is not a platitude, and it is in G4S interests, as well as anyone else, for the inquiry's work to be comprehensive and effective. That may well entail uncovering facts and matters that are uncomfortable for G4S or difficult for it to hear. It is fully alive to that prospect, but part of the responsibility of operating an IRC entails opening itself up to scrutiny when things go wrong. It's already disclosed in excess of 7,500 documents in inquiry, opening itself up to scrutiny, and its corporate witnesses will be giving evidence in the second phase of hearings next year. G4S operates widely in the sphere of government, contracting and public functions, and although it no longer runs IRCs, it does still run other custodial establishments. As such, and thirdly, G4S is not just here to help, which it is, but also to listen. G4S is here to listen in particular to former detained persons at Brook House, central to its own ability to understand what went wrong and how it was able to do so without senior management becoming aware, is to listen carefully to the detainees. G4S commends the courage of those detainees who have come forward to give evidence to the inquiry, in particular those who will be giving oral evidence. We have no doubt that it takes bravery to speak publicly about what some of these individuals have suffered, and the public benefits significantly from their courage in doing so. The other aspect is more practical. By its terms of reference, the inquiry will be investigating not only whether there has been mistreatment at Brook House and considering that against the threshold set by Article 3 of the European Convention, but also whether methods, policies, practices and management arrangements caused or contributed to any mistreatment, as well as whether any changes to such policies and practices would help to prevent reoccurrence of any mistreatment identified. In that regard, the inquiry may well make specific recommendations as to the appropriate practice going forward. Whilst G4S no longer operates Brook House, it may still benefit from any such recommendations made by the inquiry. It is likely that a number of its own procedures and practices will be in the spotlight as part of the inquiry's considerations of process and management arrangements. That means not only will G4S continue to assist the inquiry in that aspect of its work, which is already attempted to do through the corporate witness statements of Gordon Brockington and Philip Dove, but it also welcomes the inquiry's scrutiny and assessment of its processes. Both of those which were in place between April and August 2017, the relevant period, but also in relation to those improvements that it has made since. Fourthly, G4S is here to learn, so that it can do all it can to ensure that events such as those that occurred in Brook House in 2017 do not ever reoccur. That is evident from the steps it has taken as a business since the allegations of mistreatment in the Panorama episode first came to light. Its actions, where appropriate, have been swift and decisive in the disciplining and dismissal of staff, but also considered and reflective through the work G4S has commissioned by Verita to carry out a thorough independent investigation into the misconduct at Brook House and how it came to be. Real change requires deep and considered introspection, more than just replacement of staff and rewriting of policies. It is a process and a journey which G4S recognises is ongoing, and the work and recommendations of this inquiry is a crucial part of that. It's worth the inquiry bearing in mind some of the steps that G4S has already taken as part of that journey. Firstly, following the airing of the Panorama programme, the staff members implicated were suspended immediately pending investigation of their conduct. This led to 6 members of staff being dismissed and a number of leaving. G4S immediately reported the allegation to the Home Office, the relevant local authority, and to Sussex Police. It has cooperated with all subsequent investigations by external bodies, including professional regulatory bodies. In addition to longer-term reviews and lessons learned exercises, an immediate action plan was put in place to strengthen safeguarding of detained persons at Brook House, which included a particular focus on whistleblowing, increased communications to staff on the availability of the Speak Out whistleblowing channel, as well as appointing whistleblowing guardians on each wing of the centre to encourage staff to raise concerns. Fifthly, Verita were commissioned to undertake an independent investigation into the extent and root causes of the treatment of detainees at Brook House, including why senior management were unaware of the mistreatment that took place. Verita's report, as you've no doubt seen, includes 52 recommendations. All recommendations that G4S were able to implement directly were actioned. In all that work carried out in response to what has taken place at Brook House, G4S's primary concern has been the care and well-being of the detainees in its facilities. Testament to the effectiveness of those efforts in creating a safer environment than in mid-2017 is the result of the 3-week extended, unannounced inspection of Brook House in 2019 by Her Majesty's Chief Inspector of Prisons, Peter Clark. Mr. Clark found that the welfare provision was, quote, a strength of the centre, and said this about conditions generally. Brook House has faced some very serious problems over the past 2 years, with investigations and legal actions following the Panorama revelations. Nevertheless, it is to the credit of the leadership and staff that they have been determined to prevent any recurrence of poor behavioural abuse, and to inject an appropriately respectful culture into the centre, supported by improved training, better supervision of staff, and positive relationships with the detainees. That is not, nor it is intended to be, a pat on the back exercise for G4S, but it does, we say, demonstrate the dedication of the organisation and its employees to provide a safe and secure environment for those in its custody. That said, G4S does not shy away from the fact that it was its employees who carried out the conduct that was shown on Panorama. Those responsible for that conduct were swiftly removed from their posts and disciplined, but that, of course, is too late for those who suffered at their hands. That is a matter of deep regret for G4S. The fact that staff at Brook House could carry out such conduct in the ignorance of senior management has been the cause of much soul-searching by the company. It will also no doubt form a key part of the inquiry's investigations, and the company looks forward to what it can learn from the conclusions and recommendations that the inquiry will draw in this regard. They're likely to be applicable beyond the IRC context. That particular issue is undoubtedly a vexed one. The inquiry will hear evidence as to the various policies, arrangements and processes that G4S had in place to recognise safeguarding concerns at the earliest possible stage, so it could deal with them, not least through its staff whistleblowing channel Speak Out. In these circumstances, regrettably, concerns about the conduct shown on Panorama were not raised. senior management were thus not aware of what was going on, and so were not in a position to stamp it out. Of course, the fact that a complaint was not raised does not necessarily mean that the complaints or whistleblowing procedures must have been flawed or not fit for purpose, but the inquiry will no doubt have questions as to why this very troubling conduct was not raised through G4S's channels, or indeed the other structures for raising safeguarding concerns that existed at Brook House, whether through the Home Office, which maintained a daily presence, oversight bodies such as the Independent Monitoring Board, or detainee advocacy and support groups who were regularly on site and had direct access to detainees. These questions do not yield easy answers. That is precisely why the inquiry has been established. These are questions that G4S, as much as the inquiry, wants to answer. It will be therefore participating in these hearings in a facilitative and cooperative manner to assist the inquiry as best it can in understanding what took place at Brook House, for the sake of those who were detained there, but also for the sake of the inquiry producing useful and effective recommendations for the benefit and welfare of current and future immigration detainees. Before I finish, I just want to pick up on two matters in the opening speeches earlier this week. Firstly, Ms Harrison QC yesterday referred to the contract to run Brook House being agreed, quotes, by the Home Office with G4S that came in 35% under budget and did so because of, amongst other things, low staff numbers. That is factually incorrect, sorry, I do apologise. Whilst G4S did bid for the Brook House contract, its bid, which we understand included a higher number of proposed staff, was rejected by the Home Office. The successful bidder was GSL, not G4S. Now, G4S subsequently acquired GSL and at that point, of course, took over responsibility for running Brook House in accordance with a contract previously agreed between the Home Office and GSL. Secondly, Mr Armstrong yesterday raised the issue of what he referred to as missing body cam and camcorder footage in relation to particular uses of force. My solicitors will write to his solicitors directly about this. More generally, we just want to flag up that we provided the inquiry with all the body cam and CCTV footage we have in May and June of this year. Thank you very much, Chair.
Thank you, Mr Sharland. We're going to be hearing from Ms White remotely, I understand. Are we set up? Perfect.
We are.
Thank you very much. Please do go ahead, Ms White.
Good morning, Chair. May I thank you and your staff for permitting me to attend our inquiry remotely today. I am self-isolating due to COVID and intend no discourtesy to you, your representatives, or any of the core participants or their representatives through not attending in person. Can I check that you can hear me?
We can. We may need the volume up very slightly. I think we can hear you. Please do go ahead. Thank you, Ms White.
Thank you. This brief opening statement is made on behalf of the Practice Plus Group, or PPG, further to your recent determination of the 12th of November that PPG be granted core participant status in this inquiry. PPG is the largest independent provider of healthcare services for the NHS in England, treating more than 1 million patients every year. In addition to NHS services, PPG provides healthcare services in a range of other settings, including 45 prisons of all categories and youth offender establishments. All PPG services are commissioned by external commissioning bodies. As of the 1st of September of this year, i.e. for just under 2 months, PPG has operated the primary care service for the Gatwick Immigration Removal Centre at Brook House. PPG therefore had no involvement in the events with which this inquiry is concerned. As for PPG's interest in the inquiry, this has 2 dimensions. First, PPG now employs all bar one of the primary healthcare staff at Brook House, who were previously employed by G4S Health Services Limited in 2017. PPG understands that a number of healthcare staff may be asked to provide evidence to the inquiry, and that those members of staff have, hitherto, been assisted in this regard by lawyers acting for G4S Health Services Limited. Notwithstanding that PPG had no role at Brook House in 2017, PPG has assumed responsibility for the ongoing employment relationship with those members of staff. Secondly, and more broadly, PPG's interest is forward-looking and extends to all matters touching on the present and future delivery of primary healthcare services at Brook House. Consideration of current practice, policies and procedures relating to healthcare and any improvements which could be made are of direct relevance to PPG. As an organisation with substantial experience of delivering healthcare services in custodial settings, PPG hopes to assist the inquiry to identify either A, whether any clinical care issues caused or contributed to any identified mistreatment at Brook House, and or B, whether any changes to clinical care would help to prevent a recurrence of any identified mistreatment. These were the two aspects of the inquiry's terms of reference in which you, Chair, held that PPG was likely to have a significant interest in your notice of determination of the 12th of November of this year. PPG's main interest is to ensure that any recommendations which may be made for the provision of primary care services will be deliverable and achievable, having regard to those services which PPG is commissioned to provide. PPG notes that the inquiry will have the significant benefit of expert evidence from Dr. James Hard, who himself has extensive experience of GP services in prison settings. Finally, in terms of assistance to the inquiry, PPG is in the process of providing disclosure of relevant policies and procedures currently in place at Brook House. PPG stands ready to assist with any other matters or documentation which may further your inquiries, and to support this inquiry insofar as it is able to do so. Thank you, Chair. That concludes this brief opening statement.
Thank you, Ms. White. I believe that concludes our opening submissions from CPs. We have finished rather early.
Well, if that's the case, and I don't think there's any other business for today, then I invite you to resume on Monday at 10 o'clock when we will be hearing evidence first from a Home Office scene setting witness and then from Callum Tully.
Thank you very much. I will see you all on Monday.